All right, thanks for being here. Happy December.
That's very convincing.
Well, it's like hard to believe that it's December. Thank you for being here on this lovely, hot, sunny day. Appreciate you guys being here. This is always about what the turnout is whenever it's cold and rainy. So thanks for being here. Will you click? No, I got it. I just need for you to click on the, thank you. So a couple of Dorify updates that are coming that will be in your dashboard or on your portal, your dashboard portal. Sidekick, professional AI built specifically for real estate. It helps brokerages and agents turn complexity into clarity, making it easier to analyze data, communicate with clients, and make confident decisions. If you want to check it out before it comes out, there's the website there. Kubicasa is another benefit that Triangle MLS is offering us. It is a tool that will give you the ability to create accurate floor plans and room measurements in just 5 minutes using only your smartphone. Yeah. I've not been given that information. They are having an information session on December 9th at 11, where they will walk through the products, what the prices are, if any, and how to use them. And just a reminder, be careful on room measurements. Make sure that they are, if the house is brick, make sure they are accounting for the house being brick on the square footage. And Evangeline, you had one that was. Correct. Yes. However, it is, if there's no cost to it, it would give you room measurements. If nothing else, if you aren't getting, all right. I think if you'll just click on the screen, then, oh, did it die? It buzzed at me. Oh, no. All right, there we go. Okay, ad compliance. It's a lot of talk around what you should put, what should be in your advertising and what should not be in your advertising. And this is just a couple of things. You must have your broker in charge's consent. Don't send me every advertisement to approve. However, this is when in command, when you're required to upload the active listing MLS sheet, I do read those comments to make sure that you are in compliance of that rule. Again, this is listing announcements coming soon, open house flyers, market updates that mention your services, any social media content promoting your role as a broker. Every ad must clearly display the firm's name. No posting ads that only show your personal branding. So you must also include KW Central on your posting, not using, no using just your name or logo without the firm's name, no minimalist ads that omit firm identification for aesthetic reasons. On social media, the firm must be included in the actual ad content, not just in your bio or profile. So just a reminder, not just your branding, you also have to identify the firm as well. The reason behind this is not to give me, as the broker in charge, more things to do. It is so that the real estate commission can identify, the consumer can identify what firm you're affiliated with should they have a concern or complaint to the real estate commission. Never advertise or place a sign without written owner permission. So you cannot place a for sale or for rent sign. You can't post the listing and you can't promote a property online unless you have what? A listing agreement. That's what written consent is, a listing agreement. Avoid blind ads. Your ads must show you are a broker. A blind ad is any advertisement that suggests the offer is being made by the broker's principal only. Each advertisement shall indicate that it is the advertisement of a broker or firm and shall not be confined to publication of only contact information, such as P.O. box, telephone number, street address, internet, web address, or email. So what that means is that you can't place an ad and just put your phone. You can't post something and just put your phone number on there. That's considered a blind ad because I don't know who I'm calling. If you think about it from that perspective, you just put your phone number on there and I'm a consumer, and then all of a sudden it's, I get, oh, Jeff, Jeff who? Who are you with? Not knowing who they're calling. Why it matters. Non-compliant advertising, even unintentional mistakes, can result in disciplinary actions from both the commission and also from the local code of ethics, from the board, from a code of ethics standpoint too. Stay compliant, get your BIC approval, include your firm's name, obtain written owner permission, avoid blind ads, and none of you are non-residential commercial brokers, so we don't have to worry about that one. Any questions on this? Advertising do's and don'ts when using AI. So I thought this is a topic within the office. So I thought it would be a good reminder of what not to do, and also just to be cognizant of, from our standpoint, if you're showing property, what some things to be looking for. So the question is, I've been looking at how, and I'm sure none of you have run into this, but I've been looking at houses with my buyer client, and we keep seeing listings with AI enhanced photos. Online, the homes look bright, updated, and pristine, but when we arrive in person, they are often darker, dated, or noticeably worse condition. It feels deceptive, and I'm surprised it's not illegal. Is it really permitted for agents to use AI enhanced photos? Any of you ever run into that?
Okay. First picture was a beautiful house decorated for Christmas with a full yard of snow. And I was like, when did it snow like that in Burlington anytime soon? The next picture is same house with a little bit of light ice and something in front, all gross and normal looking. But they had basically said, well, it's so and so in one day. So it's just AI enhanced to have like a nice 6 inches on the entire lawn with recent Christmas things. Something that closed last year in doing a CMA. I'm like, are you kidding me?
Yeah, so something to think about. I think, Mike, you had one that the exterior they had like made the grass really green and a couple. Yeah, yeah. When you got there, it was like, oh, okay, yeah, this is not. So just to be aware. And the answer. North Carolina brokers are already prohibited from using advertising in a manner that misrepresents the property. That's whether it's by description or photos, either one. Under license law and the commission rule, a broker may not make false assurances, exaggerations, or engage in any conduct that creates a misleading impression about a listed property. That standard applies regardless of whether an image is produced through traditional photo editing tools or newer AI technology. The Code of Ethics reinforces the same principle. Article 2 prohibits exaggeration or concealment of pertinent facts. Get your words together, Karen. And Article 12 requires realtors to present a true picture in their advertising and representations to the public. Virtual staging, digital staging, all of that is becoming more popular. We're seeing it more and more. The biggest thing is disclose. I mean, it always goes back to disclose. AI, in your agent remarks, AI enhanced photos or digitally staged, virtually staged.
You're saying like in the comments, or you're saying like putting it under each photo that it is?
Yeah.
So like how you put comments under the photo?
Oh yeah, no, I was just saying just a general statement. Yeah, yes, yeah, and also load both. So if you had it digitally staged, it's fine to load those, but load the pictures in MLS of what it really looks like too.
Never seen someone say,
Yeah.
these photos are digitally enhanced or staged, never.
This is a new thing. Because I think agents are getting frustrated with going out to properties and they not being what, yeah. You know, it's just like anything. The rules change, or we create rules for those who break them, not for those who follow them. Yes.
Last week, where they did just what you said. They had the AI enhanced photo of the room, and then the next photo was the room the way it really is.
Yes.
But they had it like that all the way through all the photos.
Yes. Yep. I did see one, I think one of Rachel's listings where she put it recently in agent remarks that it was digitally staged. So yes, but even, you know, if we're putting both, then we're giving a true representation. Don't just put who's policing it? The agents. Yeah. Yes. So some of the things on virtual staging and digitally edited photos are permissible as long as they're not misleading and are clearly identified as altered. So commonly accepted are corrected lighting. You know, that's almost a given every time you have professional photography. Adjusting a perspective, removing clutter, adding virtual furnishings, provided those edits do not change the actual condition or feature of the home. Editing becomes problematic when it changes factual characteristics of the property, such as covering stains or cracks, depicting old or damaged fixtures as new, altering landscaping and or snow, or surrounding to represent a digitally remodeled after image, though it reflects current reality. If a bottom line, if a buyer walks into a home and reasonably feels that the photos present a false picture of its condition, that's exactly the kind of situation why these rules are here to address those. And again, real estate law violation, also Code of Ethics, two code of ethics violations as well. Questions or comments on that? And again, this is just a reminder from the Real Estate Commission that if you are using AI tools, clearly label altered images, maintain and display unedited photos, and avoid any enhancement that hides, minimizes, or obscures material facts. Listing photos are advertising, and advertising must give a fair and honest depiction of the property being offered. Just stay within the lanes, disclose. That's the other piece of it. Couple other things that have come up. Does the seller's signature on Form 350T mean the seller is agreeing with the buyer's reason for termination? So if you remember, 350T is the termination of contract by mutual agreement. Oh, I'm sorry. No, it's not. It's the buyer unilateral. Sorry. Oh, okay. So notice of unilateral termination from buyer to seller, 350T, from the buyer's agent. In the reasons for termination, the buyers checked two boxes, one for the buyer's right to terminate during the due diligence period, and another one alleging my seller had breached the contract. My seller is willing to release the earnest money deposit to the buyers, but does not want to admit she had breached the contract. What should I tell her? So if the seller signs Form 350T at the bottom and agrees to release the earnest money, the seller is not admitting that they agree with the buyer's reason for termination. The buyer has the unilateral right to terminate at this stage because it's still within due diligence. The seller doesn't have to agree with the buyer's right to terminate. The only thing that the seller has to agree on is who's going to get the earnest money. So in the earnest money deposit release section, the last sentence immediately above the signature block for a seller says, seller reserves all rights to dispute or challenge buyer's alleged grounds for termination, regardless of seller's decision to release the earnest money deposit or not. This sentence means that the seller is only indicating whether they are agreeing to release the earnest money deposit or not. It also means that the seller has every right to dispute the buyer's reasons for terminating if they wish at a later time. Seller is not agreeing with the buyer's reasons for termination by signing the bottom section that addresses earnest money. Again, they're just agreeing to release the earnest money, not agreeing on the buyer's reason for terminating. So another related question on 350T is, can a buyer's signature on Form 350T whether a buyer's signature on 350T to terminate the contract, even if the seller chooses not to sign the bottom section at all. The buyer's termination is effective. So once the buyer signs it, the termination in and of itself is effective. Again, the only thing that is in dispute is the earnest money. And it even states that. Should be noted that regardless of the seller's decision, the contract is terminated. Questions on that? Recently had a question about this form. Here's another little vindictive thing that some of you may have run into before. Does a buyer have to terminate before the end of due diligence period if there's no earnest money deposit in the contract? So I'm going to read this one because this one is actually kind of funny. Hey there. So I'm sure you guys don't remember, but you helped out a friend of mine a few years ago before he left on the turkey's annual big trip. Before he left, he told me how helpful you were. I'm a barn cat, so the turkey's yearly vacation plans do not really interest me, but the energy this time of year always brings some really good real estate opportunities. I'm representing a woodchuck who is selling a very large tunnel under the turkey roost. He was very clear during our listing appointment that he would not do any repairs and he wanted an as-is sale. He accepted a contract with a boggle of weasels who promised a quick as-is sale. We went under contract on Form 2T, offer to purchase, and we are getting close to the end of due diligence period. My client, against my advice, insisted on only getting a due diligence fee, and there is no earnest money deposit. The weasels are now demanding hefty concessions from my seller, even though the sale was supposed to be as is. They are saying that if they do not get them, then they will simply wait until closing to terminate to make sure that my client misses peak selling season. Can the weasels do this? Is there anything I can do to force them to decide before the end of due diligence? A couple of the smarter turkeys have reached out to me and are desperate to buy this property before their trip for some weird reason.
Actual letter.
Yeah, yeah, yeah. That's why I wanted to read the whole thing. Because this was yeah, it's the actual letter.
This part.
Yes, yeah. So, yeah, last week, right before the turkey's big trip. So, unfortunately, this scenario is common when Form 2T does not have a meaningful earnest money deposit in escrow. The due diligence period is merely a negotiated amount of time in which the buyer can investigate the property and choose to terminate for any or no reason without breaching the contract. A buyer may terminate after the due diligence period expires, and if they do not have a valid reason for doing so, they will likely be in breach of contract. If a buyer breaches Form 2T, the seller is only entitled to liquidated damages, which would be the amount of the earnest money deposit and the due diligence as a remedy. If there's no earnest money deposit in escrow, the buyer's exposure for breaching the contract is limited to the non-refundable money they've already paid. This means the buyer may not have much incentive to evaluate the property thoroughly prior to the end of due diligence. So, do we maybe change our thinking about earnest money? I know we've kind of gotten away from earnest money, and we really have been more focused on due diligence money because that goes to the seller immediately. Yet beyond that, number one, is the due diligence money enough to hurt? And secondly, is it the best protection for our seller? Because really, like they're saying, they don't have any, after they've paid the due diligence, they got no more skin in the game at all to make a good faith effort to move forward with closing. So it's an important, earnest money deposit is an important contractual term to make sure the buyer has a meaningful reason to pursue their investigations with the appropriate urgency before the end of the transaction. So hurry up and get your stuff done and investigate whatever you want. So the seller may have a few options to explore in this scenario. So there's a legal aspect to it because every contract has a good faith attached to it, right? I'm going to do this party is agreeing to do this, this party is agreeing to do this. So legal contractual of good faith and fair dealing. If a party to a contract is violating this duty, then they may be in breach, and the non-breaching party may be entitled to damages or other remedies such as termination of the contract. If the party to a contract has a future obligation to perform, and then that same party indicates that they might refuse to perform that obligation when the future time comes, then the other party may treat that refusal as a breach of contract. In the legal world, it's called anticipatory repudiation. They need to contact an attorney. If they want to go in that direction, if your seller wants to go in that direction, otherwise, they just have to, they gotta wait. I mean, and I guess it just depends on how quick is the closing date coming up to then add the 7 days to the closing date to where the seller then has the unilateral right to terminate the contract, which is what this next one is about. If the buyer indicates that they won't close, when can the seller terminate the contract? So here's the question. I represent a seller and the listed property is under contract. The due diligence period has expired and the settlement date is 30 days away. Yesterday, the buyer's agent sent me an email stating that his client will not proceed with the purchase. However, the buyer is now refusing to sign a mutual termination agreement unless the seller releases the entire earnest money deposit back to the buyer. The buyer is not claiming any legal right to terminate the contract unilaterally. Apparently, he's hoping that the seller will give up his contractual right to the deposit and terminate now so that he doesn't have to wait 30 to 45 days to put the property back on the market. Does my seller have to wait until the settlement date or maybe even 14 days after the settlement date to terminate the contract and remarket the property? Or can he terminate now based on what the buyer has told me? Again, we just talked about anticipatory repudiation. Could potentially be applicable to the situation, but it depends on a lot of facts. So again, this is where they would want to contact an attorney if they want to pursue this. They could, but they have a positive, distinct, unequivocal, and absolute refusal or inability to perform, the buyer does, before they can enforce that, and it's a high standard. So most likely, they're just going to have to wait, just like we talked about in the previous one, unless they want to contact an attorney. Working with wholesalers.
For earnest money, they gotta sign off on that even, get that.
From the seller standpoint?
Yeah, I mean, for the seller, I mean, they both had to sign off that they agreed to release the earnest money.
Yes.
How do you even get that?
Yeah.
Earnest money might not even.
Yeah, because the buyer would still have to sign off on it even after the 30 days.
So earnest
Yes.
money's still
Right.
You still gotta.
It is a, yeah, I mean, I think that it's a good point because I think that it creates the opportunity for someone for future headache when somebody is just like, especially if they're maliciously going into, well, I'll give them earnest money if that's what they're asking, but if we don't end up buying this, I'm not giving it back to them. You know, they may have that thought process going on, or their agent may even tell them that. So yes, I mean, certainly, yet if there is earnest money, then it does kind of hurt a little more when it's properly explained to the buyer that you're going to lose this amount of money as well. But yeah, I mean, you're right. I mean, at the end of the day, both parties have to agree on how it's dispersed, and, or go to court.
Wait, let it go to court.
Yeah. Okay. Should my client buy property from a wholesaler? My opinion of this is very similar to should your buyer buy a property that has solar panels? A lot of this is going on. I know if you guys are anything like me, you get probably 4 to 5 texts a day sometimes of, got any off-market properties or, all of these things. So, yeah, yeah, yeah.
You respond to it, not responding to this.
Right, yeah, yeah,
There's agents at a CRM sending out the same things to.
yeah. Yes, yes. So this buyer is very interested in a property. The property is not listed for sale by the owner. Instead, the seller is a licensed investor or wholesaler who has the property under contract with their LLC, but does not yet own it. The investor says they can convey title in a double closing. Can my client make an offer on the property? If so, can we use the offer to purchase and contract, standard form 2T? So the answer is yes. The client can make an offer. It's very risky at this point because, a couple of things. You're not dealing with the person that owns the property, number one. So do you have access to the property to do inspections? What happens if you go under contract with the LLC who's under contract to purchase the property and the LLC decides not to purchase the property? What's your contractual obligation at that point in time? And how much money do you have tied up into it from a due diligence standpoint and all that? So if it's kind of like either a foreclosure, a court-ordered sale, a sale at the courthouse steps. If your buyer is looking for something that's not messy at all, then they need to stay away from this. I mean, really, if they, because there are some buyers out there that are like, oh yeah, I don't, that's fine. I'm not in a hurry. I'll do this and, whatever. Particularly, most of the time they're investors, but your average resale buyer or, first-time buyer is not going to want to deal with this mess because really an attorney should be consulted on what happens if this happens, if this happens, if this happens, because really our standard Form 2T doesn't cover what happens if the buyer number one backs out and what happens if I'm not given access to the property to do inspections and all of those sorts of things. So one of the things that they talked about on this, you'll note, because we've got a couple of, we're going to distinguish between acceptable and unacceptable practices here in just a minute. So in this one, it's important to note that this investor is licensed, which means that he or she is subject to licensed law.
That requirement, I heard they were gonna make it to where the wholesalers or somebody, even property managers of their own would have to be licensed.
So you can always sell. I know that there's a statute that is under consideration right now in a legislative statute. You can always sell your own property without being licensed. You just can't service someone else's property whether it's property management or whether it's selling. Yes. Yes. Yep. And there's also some potential discipline for agents who engage with unlicensed wholesalers or investors. I would make sure if you are in this situation or looking to get into something of this, that you go to the Real Estate Commission website and click and read a little bit more about what some of the potential downsides could be. So again, it's important for the buyer to note some specific risks that can come up. We talked about the buyer may not have the ability to do due diligence because the investor's contract may not provide the right for any access. The ability to negotiate repairs may be very limited or unavailable. The owner may decide to back out of the transaction, which means the seller may not be able to complete the transaction without pursuing a lawsuit. There's a lot of other risks as well. Those are kind of the biggest ones, and also the reason why Form 2T is not a good fit, and it should be drafted by an attorney. If your client does make an offer, contract terms like the amount of due diligence fee, if any, or the purchase price should reflect the possibility of at least the above risk. Hopefully the property lives up to your client's expectations, but should the transaction hit bumps along the way, make sure your buyers know the dangers up front knowing the dangers up front will be invaluable. So when somebody asks you about that, then this is where you would just might want to share this with them. Okay. Segueing straight in, talking about wholesalers, segueing straight in to unlicensed activity in North Carolina. So the Real Estate Commission takes it very serious. Unlicensed activity can typically be divided into two categories. Individuals and entities that do not possess a real estate license and are engaged in real estate brokerage activity in violation of the North Carolina general statutes, and licensed individuals and entities that are engaged in prohibited real estate brokerage conduct with individuals and entities that are not licensed. So you've got the ones that aren't, that are doing it anyway, and then you've got some that are doing it with the bad guys. Yeah. So North Carolina General Statute defines a real estate broker, any person or entity who for a compensation or valuable consideration or promise thereof lists or offers to list, sells or offers to sell, buys or offers to buy, auction or offers, negotiates the purchase of a sale or exchange of real estate, who leases or offers to lease, who offers to sell or offers to sell leases of whatever character or rents, or offers to rent any real estate or the improvement thereon for others. For others is the key word. So basically all of that I just said is what? Real estate, right? Yes. Any of those things, and the two key words are for others. Again, you can do all of that stuff for yourself and not have to be licensed. You just can't do it for others. It's a class 1 misdemeanor. It's violated.
I'd like to police somebody too. Get this woman a badge, please.
Absolutely. Yeah.
So,
If any of those, so if you are dealing with an individual that is doing any of those activities that I just read and they are not licensed, then they are in violation of the real estate statute. which is a Class 1 misdemeanor, which is only one stage under a felony.
We had any wholesale deals come through our office, or they always deny, you know?
That's what, I was just asking, are those like weird listings you see where you're like info in private marks, and it's like, go to this weird portal and put all your crap in, and this is the only way you submit stuff, and like, you're like, this sounds strange, and why would I not be using an OTP, and I don't wanna go to this kind of portal.
Yeah, so a couple of them, well, it just depends because some of the REO bank-owned they use portals, and thanks to Jason Cox, the agents have to go in themselves and enter it in themselves. Those of you that don't know, Jason Cox ruined the foreclosure REO business in Alamance County, where it made nobody trust anybody for all of his actions.
Anything fishy that was going on, but.
Yeah, he's still, he doesn't have a license anymore.
Okay.
Yeah, no, he doesn't have a license anymore. But yes, so multiple offers. I mean, this was like when, well, this is like, well, he was licensed, but he was investigated by the SEC, as well as, so the Real Estate Commission was not really a big deal when I was actually interviewed by the SEC because I,
Oh, this dude,
yeah, yes.
he's from Brother.
Hmm.
Chase out of town.
Oh, he don't do Brother.
Yeah, he's gone. He's gone. But not only was he having his investors outbid other people when multiple offers were coming in, one of his investors just happened to be his dad. And then he also created a side business that was trash out, lawn care, all of the things that are, as an agent is required to handle with a bank-owned property. And so
I actually reported into two of his REO people. And they were like, "Oh, you're just kidding with me." I said, "No, you need to check into this." And then it was like 6 months later, it really started coming down.
yeah. Yes. So upon here, Chris, I think this might answer your policing question. Upon receipt of any complaint regarding unlicensed brokerage activity, the Commission's Regulatory Affairs Division will investigate the matter. The Commission first tries to get unlicensed person or firms licensed. If that does not work, staff seeks cease and desist consent agreements with those who may be violating state statuses. If Regulatory Affairs is not able to reach such an agreement, enforcement action may be necessary. In civil enforcement cases, the Real Estate Commission is represented by the Attorney General's office to seek an injunction in Superior Court. Criminal enforcement actions are handled by the local district attorney's office. So, they ain't playing. I know. It's the way it should be. So these are some examples of unlicensed activities that may involve these kinds of legal actions. Managing properties belonging to another without a license. A licensed person has become a superhost utilizing Airbnb to market and promote their short-term vacation rental property. Two friends have asked the superhost to market and manage the friend's Airbnb property as well and agree to pay the superhost a percentage of the rental bookings. The advertising, marketing, and management of a property belonging to another for compensation requires an active real estate license. So, again, you can manage your own Airbnb, you just can't manage somebody else's. Wholesaling, again, here we go. A real estate license is not required in North Carolina for a bona fide buyer to assign their rights and interests in a purchase contract to a third party. However, the wholesaler may be engaged in unlicensed brokerage activity in the violation of the statutes if their conduct involves any of the following activities: soliciting and marketing to sellers that wholesaler will purchase a property for cash when the wholesaler has no intention of personally purchasing the property, but instead plans to secure buyers for a fee to purchase directly from the seller. That's the definition of wholesaling. Misrepresenting their ownership interest in the property, collecting, handling, and delivering due diligence fees and earnest money deposits on behalf of a third party, i.e. the sellers, negotiate purchase contracts between a buyer and a seller, acting on behalf of an investor entity when the wholesaler is not an officer or W-2 employee exempt from licensure under a separate general statute. Soliciting and marketing of buyers generally unconnected to the transfer of a specific assigned purchase contract. So this is an example of when you guys sometimes get those offers that are those like one-page offers, or sometimes they might be two-page offers that essentially says that they will allow, the seller will allow the buyer to put a sign in the yard, to market the property, to all of that kind of stuff. Yeah, that's illegal. What? Oh, I get a lot of those kind of offers. Well, that's good. That's good. Okay, second major category of unlicensed activity involves licensees engaging in prohibited conduct with unlicensed individuals or entity. The commission has the power to discipline a broker by reprimand, suspension, or revocation when the broker engages in prohibited conduct. So you're not going to go to jail, but you're not going to have a career in real estate. So some of examples: payment of referral or finder's fee to unlicensed people or entities. So one of your past clients, favorite past clients on your VIP list, gives you a lot of referrals. What can you give that person? A thank you note. No gift card. Yeah. You can give them a thank you card. Yes. Yes. Now, that doesn't mean, so a lot of agents will have their VIP list, which may consist of people that have bought multiple properties from them, people that have referred multiple people to them. And so that's their VIP list. There's absolutely nothing wrong with hosting a client VIP event.
With door prizes?
As long as everybody gets the same thing. So, be aware of that. Any type of cash or monetary payment is in violation of the general statute. So is the receipt of a gift card, free movie ticket, the dinner gift certificate, or any item that is valuable consideration. Brokers who share fees with wholesalers based on the wholesaler representing or referring, providing a buyer, again, that's a violation. Licensees directing unlicensed people to solicit business. Your unlicensed assistant cannot call your database. Your unlicensed assistant cannot make cold calls for you.
And to invite them to the client event.
Correct.
I mean, isn't that technically what they're doing?
Yeah,
You just have to be licensed.
you just have to be licensed.
If they're gonna be. Or that's not.
Good luck tracking them down.
Yeah.
Of course, they'll track you down.
Yeah.
Yes. Brokers are permitted to utilize unlicensed assistants for administrative tasks that do not require a license. Prospecting, making cold calls, and gathering financial, motivational, and confidential information from consumers requires an active license. Becomes first substantial contact and also requires the working with real estate agents. Brokerage services provided by inactive or expired. When a broker's license becomes inactive or expired, the broker is required to immediately cease all brokerage activities. A broker whose license status has changed from active may not continue to work with consumers, even to complete a pending transaction or advise existing clients. So, take your CE, pay your renewal, and you don't have to worry about your license becoming inactive or expired. Yes,
Are there any kind of, video? But
for the referral. Yeah, I mean, in other words, everybody, you can host an event and, everybody gets a holiday ornament that's set at their chair. I mean, yeah, yeah, yeah. But just not individually in response to the sending the referral. But I'd be real careful with that. There could be 3 people there. Then I would just maybe pay for their dinner. Don't add in an additional gift card.
I do one program to 3 or 6 people. That's what I'm trying to figure out.
Well, you're not supposed to give it to any of them at all. I was just suggesting perhaps a gray area where it might not be quite as you remember, I'm being recorded here, Donna Marie. All right, real quick, a couple of disciplinary actions. Baker acted as a listing agent on a failed transaction. During the course of the transaction, the buyer placed a stop payment order on their earnest money check, and Baker's seller, who lived out of state, wanted to sue the buyer for the earnest money. Baker, who is not an attorney, filed a civil complaint in small claims court on behalf of his client for the disputed funds. Okay, you cannot do that. I understand that we want to provide great service to our clients. However, reminder of what we do real estate, we do not do law. So we do not file any type of court cases on behalf of any customer or client. An attorney needs to do that. And then we have Sanchez was suspended, broker's license suspended for 36 months and then stayed for a 6.5 month active period under certain conditions, probation. The commission found that Sanchez acted as a listing agent and provided a lockbox code to a potential buyer without the seller's consent. Not only are you going to make the bulletin, you're also going to get hit with a very heavy fine from MLS for that type of behavior. Sanchez requested payment of a due diligence fee after falsely communicating that an offer was accepted and under contract before a written offer was submitted. Sanchez misrepresented that the property was stick-built even after being provided with the manufacturer label and failed to provide transaction documents to his broker in charge in a timely manner. Sanchez failed to fully disclose material facts learned from the first buyer's inspection to a subsequent buyer. Sanchez got a whole lot going on right here. He's done a whole lot. I mean, this is not just one of them. This is kind of like Chad that we talked about last month. Chad made the bulletin 3 separate times. Don't be a Sanchez, don't be a Chad. Yes. Fair housing, just a reminder, it's on the cycle. We always follow fair housing. Legal hotline, great way to get questions. And then that's just our final reminders. Any questions for me? Thank you all for being here. Finished right on time. Not my usual 7 minutes late. Reminder tomorrow, 1 o'clock in the agent workroom is forms. There'll be listing forms tomorrow. See you there.
$8 for the day?
Oh yeah, did
Oh,
Get Park Street and lunch, come on now.
you only bought from home forward, you said you were giving me in the truck then.
You're right, I'll give it one. You're right, I'll get him to.
I thought I had a lot of that showed up. I thought that came in fresh, you know, that did they?
Here you go.
Thanks, sir.
You're down the right one, too. On the home floor. But I said I was gonna give you a, I'm bird.
Oh, but on the farm? I guess I'll remove your name from all this part.
Thanks, Jeff. Thanks for being here.